Hi, everybody. Welcome back to Ox Talks, another episode of Stay Out of Court. I appreciate you guys watching these videos and supporting the channel. Please like, share the videos with as many people as you possibly can, and subscribe to my channel if you haven't already subscribed. So again, thank you. Let me jump into a topic that's been on my mind for a few days since I attended a private mediation with a client on a case just this last week. And what the case did not settle, and what it again revealed to me is just the fallacy with the system and the weaknesses in the judicial system that I have encountered. I continue to see now practicing law almost 30 years. I'm not giving you specific legal advice in these videos. In this video, I'm just I'm sharing some information with you, some events and stories that have happened that I've personally been involved in and witnessed. And you need to go see your own your own lawyer, get your own legal advice in whatever state or jurisdiction you're in. The laws vary from state to state and jurisdiction to jurisdiction, okay? These are just meant to be hopefully some helpful hints, some warnings. I want to expose pitfalls with the system, pitfalls with different legal issues in my continued endeavor to help people stay out of court, okay? That's the title of this series. So let me jump right in. I was in this mediation a few days ago, and it's a construction dispute where my client hired a contractor to repair a residence after a fire damage, and the contract was a few $100,000. And I'm just going to use numbers, not specifics, because it's an active matter. And the contractor alleged that he wasn't paid. We believe that he abandoned the job, and so the contractor put a mechanic's lien. I'll do a whole separate video on mechanics liens and how dangerous those can be for a homeowner. But the contractor recorded a mechanics lien, filed a foreclosure mechanics lien action. We filed a counterclaim alleging abandonment and breach of contract, negligence, and all those things. Anyway, in this jurisdiction, in Southern California, before you're able to get a trial date on a case, the courts, for the most part, mandate that the parties go through some sort of alternative dispute resolution. Usually it's a private mediation. In some circumstances, the court system offers a free mediation program, but in our jurisdiction, that's been hit and miss since the pandemic, in terms of its availability, right? And in terms of, availability and whether or not the court's even offering it at the time. So the fallback is you have to go to private mediation. What that means is the parties have to hire and usually split the fees and the costs for a private mediator who is either an active attorney who does mediations, handles mediations, or sometimes a retired lawyer. Many times retired judges go into private mediation and act as mediators for cases. But the bottom line is they're not cheap. They charge hourly. And so what a client has to do is not only pay their own lawyer the hourly time to prepare a mediation brief, submit it ahead of time, then have the lawyer pay the lawyer to attend the mediation, which usually goes on for 6 or 7 or 8 hours over a period of a day. And so it's very, very expensive, okay? And in this situation, this comes up all the time. And it's why I'm warning people through these series to do everything possible to stay out of the legal system. And here's an example of why. Because you end up oftentimes being in a situation where you're almost a hostage. And what I mean is this, speaking in generalities. When the mediation demand from the other side is you don't believe it's viable, you don't believe it has merit, and you believe, let's say, if you're sued in a case that you were wrongfully sued, okay? And so you now have an opposing party and a lawyer sitting there making a demand that you pay them X amount of dollars on a claim that you think has no merit. Maybe you even have cross claims, believing not only do you not owe them money, but they owe you money, okay? So you have these counter demands going back and forth during a mediation process where the mediator is shuffling between the two rooms. Sometimes now they're virtual rooms. These things are done by Zoom a lot now since the pandemic. but trying to resolve the case. A mediator does not act as a finder of fact. A mediator is just a settlement conference judge or person, if you will, simply trying to bring the parties together to settle the case, to end the litigation. So you have the situation where you have demands from each side, and you get to a point where the demand is not something you're willing to accept. They don't want to pay your demand. But if you go forward with the case, the next step in many of these cases, we get a trial date and we have to retain experts and get depositions completed. And usually the expensive part of the case, if you will, unfolds after the mediation. Not always, but often, okay? So you're in a situation where if you do not accept, if you will, or, let's say, swallow the demand they're making and write a check, you end up having to pay your private counsel to continue the litigation actually more than you would have had to have paid had you just acquiesced to their side's ridiculous demand. So when I say you're held hostage, you really are. It's almost like you have a gun to your head, because if you look at this stuff strictly as a business situation and you try to keep emotions out of it, and lawyers try to have their clients do that, it's impossible. When you're involved in litigation, emotions are, it's just human nature, right? But if you can set aside the emotions and look at these things as business transactions and hard-earned dollars, right? Every dollar you earn is a hard-earned dollar. It's hard to earn and it's hard to replace. So how do you best allocate the resources that you have? A lot of times you're taking a settlement where you have to make payments just to get out from under the case and stop paying your lawyer and eliminate the risk of going forward. I've been involved in so many cases where the client rejects a demand at mediation. They want to go to trial. They go to trial. They pay the legal fees to go to trial, obviously very expensive, and they lose a trial. And of course, in hindsight, then they could have gotten out under the case for what would have at that point in time been a much fraction of the dollars ultimately spent. So guys, you have to be very, very careful. And it's even as a participant, not a party, but the lawyer in these kind of things. I see the pain on the clients' faces. I understand it, because they don't understand how they can get dragged in a lot of times as a defendant in a case where they believe they've been wrongfully brought into a case or sued, that the claims have no merit, yet they still have to turn around, or not have to, but they're being called upon to contemplate writing a check to your side to get rid of it. You're almost paying ransom money. And what I tell clients often is, look, I know this is not, you don't want to do it. We understand your defenses are strong, but if you don't pay to get rid of the case, you end up paying me or somebody else to continue on with the case to take it to trial. So that is when I say the system is jacked, that is one element that I see come up a lot in my practice that it saddens me, because there's no way around it. When you're in an active case, if you're a defendant, you got to defend the case, unless you're going to roll over and let a judgment be entered against you, okay? So please keep that in mind. It goes back full circle. Do everything you can to avoid legal disputes, okay? With that being said, I don't want to go too long today. I'm trying to keep these series under 10 minutes, so you guys will watch all of the show, hopefully, and share it as far and wide as you can, so people wake up to this stuff. All right. With that being said, talk to you all soon. Bye.